Hello everybody, my name is Larry Rosen. I'm a managing partner with IHSS Advocates. Today we're going to discuss 3 key elements for distinguishing significantly more supervision from routine child care in a young child. Obviously, as an advocate, that's the specialty that IHSS Advocates engages in. We focus on getting protective supervision for children who are extremely young. There was a time when IHSS was first initiated where children were not considered to be part of the population that would be allowed to get protective supervision, and it was commonplace at one point in time for social workers to deny without actually doing assessments. And it wasn't until 1998 when Garrett versus Anderson was a superior court made a decision. It was actually a stipulated decision creating rules for assessing minors for protective supervision. And some of the highlights from that court decision, which are found in all County Letter 98-87, include that a social worker should always assess an IHSS eligible minor for mental functioning, and not to presume that a minor of any age has a mental functioning score of 1, which would be no impairment. A social worker must evaluate a mentally impaired minor in the functions of memory, orientation, and judgment. A social worker must assess a minor's need for protective supervision if the minor has a mental impairment. So if you've got regional center, for example, or you've got an IEP at school and it states on there that there is a mental impairment, well, that is in writing sufficient reason for a social worker to conduct a assessment of memory, orientation, and judgment. Also, social worker must assess each minor with a mental impairment for PS based on individual need. In doing so, the social worker must request the parent or guardian to obtain available information and documentation about a minor's mental impairment, including other agency records like those from regional center, with the written consent of parents or appropriate persons, and then review such information and documentation. A county is not required to independently obtain such information and documentation, but they must ask a parent or guardian to do so. And the last piece, which I think is extremely important, and we'll explain exactly what it means in this presentation, a minor must not be denied PS based solely on age. So in 2015, the California Department of Social Services introduced another all-county letter, 25, which is a update based upon the Garrett rules for assessing children for protective supervision. And in doing so, they created a 4-step process, which we've discussed, I believe, in the past. It has to do with the fact that the first step is that the child be determined to be non-self-directing. Second step is the child have the mobility to put themselves in harm's need. Third is that the recipient require a significantly higher level of supervision based on the mental impairment than another child who does not have a mental impairment. And number 4 is that the need be 24 hours, that the child required 24-hour supervision in order to remain safely in the home. But the all-county letter 1525 also clarifies some of the Garrett rules, indicates that their social worker is required to assess all eligible minors for mental impairment, mental illness, and request the parents or guardians obtain available information and documentation about the existence of a minor's mental impairment, mental illness, evaluate a mentally ill, mentally impaired minor in functions of memory, orientation, and judgment on an individualized basis, evaluate a mentally ill, mentally impaired minor even if there are no previous injuries, and evaluate a mentally ill, mentally impaired minor regardless of age. Why is this important? Why is it important that there is a distinction between all County Letter 1525 and the Garrett 98-87 all county letter? Well, the reason is that at the time in 1998, it was common practice for social workers not to even do assessments. And now, in 2015, a rule was essentially clarified that stated that yes, a social worker could find that there is an individual who is, say, for example, age 3, and does require or does exhibit non-self-direction, but is the non-self-direction significantly higher in order to warrant protective supervision. And so, based upon the rules clarification in 2015, whereas back in 1998, social workers would simply not assess at all, well, now the rule is that after assessing and after looking at all the documentation, the social worker still has the ability to deny based partly on age. In other words, they're still making a finding that the individual is non-self-directing, but the non-self-direction does not result in a significantly greater need for protective supervision than a typical child of the same age. And so that's really the reason why we're having our discussion today. What characteristics are there that would separate a child who has, say, for example, autism, who is, what makes them different from another child with autism? Why is it that one child age 3 with autism could get protective supervision, but another child without autism might not qualify for protective supervision? The first thing I want to make sure that everyone understands is that the California Department of Social Services has made a determination that it is possible for a 3-year-old to get protective supervision. It's actually found in a document that was published by the Training Bureau of the IHSS State Hearings Division, and it's dated March 27th, 2000, item 00-03-01A, and I am reminded that after this presentation that we will have a packet available online, and that if you provide us with your contact information, we'll be able to email this to you. But they ask specifically, the document is a hypothetical, and they ask whether it's possible for a child age 3 to be granted protective supervision. And what the answer is that the county is not permitted to presume that a child of any age has a mental functioning score of 1, which would be that there be no impairment. And it goes on to state that the county must determine whether a minor needs more supervision because of his or her mental impairment than would a child of the same age without a mental impairment. The child must not be denied protective supervision based solely on age or because he or she has incurred no injuries in the home due to the mental impairment. The county must allow the parents, guardians to provide medical or other information about the mental impairment and must evaluate that information. And then the document ends stating, since the county is not permitted to presume that a child of any age has a mental functioning score of 1, it is possible for 3-year-old Mark, and they use Mark in this example, it's a hypothetical, to have an established need for protective supervision. The parent guardian would have to present both medical and testimonial evidence to support the contention that Mark required more supervision because of his mental impairment than would a 3-year-old without such mental impairment. Now, there are certain documents that we use as advocates that help us in making the determination that an individual needs a higher level of supervision versus a typical child without a mental impairment. Those documents are documents that would typically be drafted around the time of transition at age 3. And those documents would be regional center documents for individuals who are transitioning into regional center from early start programs into the typical regional center program. It also would include documents that would be drafted for school purposes, like an IEP. And it would also include, because typically when an individual transitions at regional center or at the school district, there's typically a psych assessment that goes along with it. And so these are documents that are typically drafted around the age 3. And so we as advocates believe that age 3 is the correct age in which to start pursuing protective supervision. You have plenty of documentation to work with. That's third party. As I mentioned, the school does their testing. Regional center does their testing. And so you now have new third-party evidence to show that there is a significantly greater need for supervision based upon a mental impairment than a typical child of the same age. Now, as advocates, one of the things that we are able to benefit from is the expertise of administrative law judges. And given the fact that we do a high volume of hearings per year, we actually are able to read a lot of responses from various ALJs. And some of the comments that are made by ALJs in their decisions are extremely useful. They're not regulatory, they're not statutory, and they cannot be cited. However, common sense. They are opinions from individuals who obviously do this repeatedly as their livelihood, and therefore they do have an insight that is distinctly higher than that, say, of a typical layman. And so given the fact that it's coming from an ALJ, and given the fact that when they make these opinions, they're typically supported by either fact or by legal reasoning, they're very useful. And what I like to read here is, I can't cite these because, like I mentioned, they're not something you can cite, but I can read you the quote that's been given by an ALJ, and I'm going to leave the ALJ as anonymous. And these are helpful in regards to making the determination as to whether your child at age 3 would be able to get protective supervision versus another child who might not. And so in this administrative hearing decision, the ALJ shared these quotes. In addition, nothing in the IHSS regulations limits protective supervision to only those with absolutely no degree of understanding whatsoever. As stated in Calderon v. Anderson, which is a Superior Court case, IHSS is limited to beneficiaries who are for any reason non-self-directing, and that they are unaware of their physical or mental problems and unable to watch out for themselves. Additionally, thus, to the extent self-direction comes into play, the question is not whether the individual has no ability whatsoever to self-direct, such as following directions in physical therapy. Instead, the question is whether, due to mental impairment, the individual is unable to assess danger and the risk of harm, and therefore would most likely engage in potentially dangerous activities that may cause self-harm. Here, the record is replete with evidence of the child's inability to assess danger and risk of harm and is engaging in potentially dangerous activities, such as wandering, jumping, and falling. The county's contention that all 3-year-old children require close supervision appears to be based solely on the child's age and not his inability to self-direct. In other words, this judge actually thought outside the box and came to the realization that there is a distinction between a child that is, say, 3 years old and in a general preschool, and a child that's age 3 years old and is a regional center consumer, been diagnosed with a mental impairment, and is in a special day class as opposed to a general ed preschool. And they make the distinction that there are certain factors in which you could use in order to make the determination of whether a child requires significantly more supervision based on a mental impairment at age 3 than a typical child of the same age. So what else do ALJs say? So another ALJ, a very wise one, and once again I'm going to keep these anonymous, but I obviously as a advocate I do have my favorite ALJs. I'm not going to lie about that. There are certain ALJs that are more apt to rule in favor of claimants than other ALJs. But I wanted to state that this ALJ created on their own a system in which to gauge whether or not an individual requires a higher level of supervision, significantly more level of supervision at age 3 than a typical child without a mental impairment. So I'm going to read this verbatim once again. There is no standard that the administrative law judge is aware of that measures the intensity of a required supervision of a normal child at a particular age. So the only possible measure would be that based on common knowledge. At the age of 1.5, a child is just beginning to maneuver and has not developed much in the way of communication skills. It is time when any parent has to provide very intense, eyes-on supervision. However, when the child reaches the age of 2, the child is communicating much better and is usually no longer at risk of continually falling, and the supervision can begin to be less. By the time the child is at the age of 3, there is even a more significant change in the level of supervision required. When using the above measure, the documentary evidence and the testimony does reflect a considerably greater need for intense supervision than that required by a normal child. Once again, this is from a judge's decision. A normal child does not engage in headbanging on a regular basis, if at all. A normal child will react and learn from parental directions. The testing evidence reflects that this child has a behavioral age that is significantly lower than his chronological age. All this evidence requires the conclusion that the applicant requires far more supervision than a normal child of the same age. So what we've done as advocates is we've put together 3 key elements for distinguishing significantly more supervision from routine child care in a young child. And I'm going to share those with you. Number 1, ask yourself, does the child engage in anomalous, potentially self-injurious behavior, such as headbanging, on a regular basis, if at all? It is not typical for a 3-year-old child without a mental impairment to, as a result of being told, you have to turn off your TV, we're going to the store, to engage in headbanging. Especially in some cases with some of the families that I encounter, that headbanging can go on for minutes. It can go on, the tantrum itself can go on, in some cases, as long as an hour. You know, with some kids who are extremely mentally impaired, specifically with autism, level 3, the rigidity is very, very strong, and that tantrum can go on forever. So when a social worker states that tantrums are excludable because they are self-directing, the correct response would be to determine what the specific elements are to the tantrum, because not all tantrums are the same. Some kids tantrum, they cry, they kick, which that would not be something that would be worthy of protective supervision simply for the fact that that's not potentially self-injurious. Some kiddos will throw things at other people when they tantrum. They might hit other people when they tantrum. Once again, unfortunately, that is going to be excludable because that's going to be considered to be antisocial or aggressive behavior, as those behaviors are directed towards another person. However, in the event that the tantrum escalates to a point in which involves either headbanging or hitting themselves or biting themselves or scratching themselves, and the behavior is something that appears to be random and does not appear to be something that is typical, and certainly not something that would be considered to be intentional, and it's related to the mental impairment. Say, for example, the individual has been diagnosed with level 3 autism, well, then you can make an argument that those specific behaviors are worthy of protective supervision, even in a child of 3 years old. Second of the elements, a normal child will react and learn from parental directions. A typical 3-year-old child, when they're walking away from you and you call their name, should turn around. They should stop when you tell them to stop. They should come here when you tell them to come here. So, which is in the case with some kiddos who are very, very young and have mental impairments, they don't respond to verbal prompts. And so instead of you being able to redirect or being able to control them simply by, telling them to do something across the room, it would require the individual to run over and to physically grab the individual, the child with the mental impairment, to physically grab the child with the mental impairment and redirect them physically. So it requires a distinctly different level of prompting than that from a typical child age 3. And the third key element is that the testing evidence reflects that the child in question has a behavioral age that is significantly lower than the chronological age. So that's going to be something you're going to find in your documentation. So most kiddos who require protective supervision at age 3 have either gone through a psych evaluation, either for transitioning at a regional center or in the school district. Sometimes they have ABA, which would have some testing data also. And so you want to use the data that you have in your reports in order to establish that there is a significantly greater level of need based upon a deficit in mental functioning, based upon a deficit in chronological age versus the behavioral age. For example, I have a case that I just recently received a affirmative decision from an ALJ in which the recipient was age 3, but the functioning age on the reports was age 1.5. And so I was able to argue that the child was delayed by 18 months and that as a result of the delay, that it impacted the ability to reason in regards to the other behaviors. So those are the 3 key elements for distinguishing significantly more supervision from routine child care in a young child.